Okay, is everybody? Yeah, welcome everybody. See, we've got 20 plus of you. I'm David Johnson from the Language, Literature and Politics Research Group. Welcome and thanks very much for making the time to come along today. This is the fourth talk in our series on resisting the hostile environment. And briefly, the aim of the group is to nurture cross-disciplinary conversations and connections within the Open University and beyond about areas of common interest. And this is the fourth series we've hosted. The others on keywords, on the meaning of freedom and the critical citizen. And in this one, what we've done is we've taken as our point of departure the resisting the hostile environment. The phrase generated, although I believe it's got an earlier life, but it was generated in most famously, or it's generally marked as commencing in May 2012, when Theresa May, as Home Secretary, declared the aim is to create here in Britain a hostile environment for illegal migration. What we don't want is a situation where people think they can come here and overstay because they're able to access everything they need. So as I say, this is the third talk, and we're particularly pleased this week because we've got a lawyer who knows about the law and about the law related to migration and the rights of refugees. And so I'm very pleased to introduce Kate Ritchie, who will talk about the Rwanda case, resistance and counter-resistance. But briefly, before I introduce Kate properly, I'll just remind you of the housekeeping things. The first is just to mute your microphones and turn off your cameras during the talk. And then also just to invite you to type questions into the chat box during and after the talk, and then I'll invite you to speak to those questions. Just a reminder too that the talk is recorded and will be hosted on the website of the Language, Literature and Politics group. That's just the talk, not the Q&A. I checked this afternoon, and the first three talks in the series are already up on the website, so you can go back and look through them if you want to catch up. Okay, so just to introduce Kate briefly, and welcome her again. Kate is a lecturer in law at the Open University. Her research is on the rights of migrants and more generally the theme of belonging. She became interested in this area when studying her master's, exploring the rights of maritime migrants in the central Mediterranean and the impact of the European Convention on the rights of those migrants. And more recently, as maritime migration has shifted closer to Britain, she's followed the development of the Rwanda policy very closely, and it's as part of the manifestation of the hostile environment and the resistance to this in the courts in what have become known as the Rwanda case. The case was finally decided in the Supreme Court in November 23, and it is this case that's going to be the crux, the core of her talk, but she'll obviously pick up on stuff that's happened since then. A lot has happened since then. It's sort of a hard thing to come up. And then briefly, I'll just introduce, we always have invite a respondent, and we're very grateful to Sophie Doherty, also a lecturer in law at the Open University, who I'll introduce to ask Kate the first question. So, but yeah, over to you, Kate, and thanks again.
Okay, thanks, David, and welcome to everyone. Thank you for coming. So as David said, I'm going to talk about the Rwanda case and how the law has been used as a tool of both sort of resistance and counter-resistance in terms of the hostile environment that policy that underpins that case has created. So there is the Rwanda policy summarised. The domestic law framework is primarily in two acts, the Illegal Migration Act and the Nationality and Borders Act. And these two acts basically say that if a migrant comes into the UK irregularly, so if they don't come in through a recognised resettlement scheme, such as one for Ukrainians or people from Hong Kong, or say a community sponsorship scheme, something of that nature, they are illegal if they could have claimed asylum in a safe country, so a country like France. So that sort of clarifies that they are illegal migrants, and if they are illegal migrants, they can be deported to have their asylum application processed in a safe country, and even if it's successful, they then have to stay in the safe country. They're not able to then reside in the UK. So that's the sort of the basic foundation of the policy. And then they had to find a safe country to deport to. So that brings us to the next point, which is they entered into this international arrangement with Rwanda. Originally, it was a non-binding memorandum or agreement in which Rwanda agreed to take asylum seekers, and it's now been formalised as a treaty, which means that it's a binding legal instrument under international law. And I will talk. I'll explain why they've done that in case you may have come across that in recent weeks, but I'll explain further why they've done that. The stated purpose is to deter migrants crossing in small boats. So I mean, they claim this is sort of altruistic, that it's to save lives and to clamp down on human smuggling. But I think it's also pretty clear that it's become a sort of flashpoint and that they recognise that politically it serves their purposes, because there is this concern amongst big sections of the population that the migrants that are here that have not been processed are impacting on resources and amenities and so on. The effect of the policy is that they've set this up to deport illegal migrants to a safe country, Rwanda. So just before we start looking at resistance to this policy, it's probably just worth looking at some of the data. So in 2022, there were over 445,000 people crossed in small boats. In 23, that dropped actually to 30,000, is still high, higher than in 21. So the government are already claiming that the policy has had a deterrent effect, but there are other reasons which I think are probably more valid. One is that if you look at the figures, that the biggest drop in terms of nationality is in Albanian. So that's somewhere between 30 and 35% has dropped down to 3%, probably due to a returns deal with Albania. So that's probably explains that discrepancy. It may also be due to bad weather. In 2023, it was a bit worse. It seems unlikely that the Rwanda policy has had much impact when they've certainly anecdotally interviews with people in the Calais camp. People don't really seem to be registering it and are determined to go ahead and cross. So it seems unlikely that the policy itself has had that deterrent effect. And actually, the border control authorities are predicting that numbers will go up again in 24 because there has been another surge in migration into Europe, and that's going to there's always a bit of a delay in that hitting the UK. So this is undoubtedly true that a lot of people are crossing in small boats. And I mean, yeah, I'm not going to spend too long talking about why that is, but essentially there aren't many legal routes. Unless you're of a particular nationality, or you're lucky enough to get on a community sponsorship scheme or a family reunification scheme, you can't just go into an embassy and claim an asylum visa. And it's getting harder to sort of stow away on ferries and things. The detection technology that they've got in place now, particularly in places like Calais, is making that harder and harder. So that probably explains primarily why there has been such an increase in crossings in small boats, and obviously, just generally there's an increase in migration because of increase in conflict, increase in pressures of climate change, and so on. Oh, has somebody said there's a problem with sound? Can anyone hear? So I'm not.
Yeah, I think it's fine. Okay, it's probably.
Oh, good. Yeah. Sorry. Okay. So resistance to the Rwanda policy. So in June 2022, a judicial review case was brought by some of those who were on the list to go to Rwanda to challenge the lawfulness of the Rwanda policy. And this is what's become known as the Rwanda case. So a judicial review case is one where the actions or decisions of a public authority are challenged. And in this case, it was specifically that it was felt the Rwanda policy breached certain human rights under the Human Rights Act. The European Court of Human Rights granted urgent interim relief to prevent deportations pending hearing of the case. It was just as well he did that because the domestic courts dismissed the claims for that relief. So there was resistance there. And then the High Court heard the case in December 22. The High Court ruled in favour of the government and declared that Rwanda is perfectly safe and the policy is lawful. So they decided that not only was Rwanda itself safe, that even though there was evidence that Rwanda oppressed political opponents, that those other asylum seekers who had protested about their conditions had been injured and some killed, I think, as well. They decided that Rwanda was safe for that purpose, and it was one of the key things they focused on was whether or not there was a risk of refoulement. Refoulement is a French term, and it refers to the sending on of asylum seekers to a country which is not safe for them, where they are at risk of torture or inhumane treatment in breach of international law. So the question of safety is not just about what happens in that country, but also about whether they are at risk of being sent on. And so, of course, that requires you to look at how rigorous and how safe the actual system of asylum processing is. The High Court said they didn't feel they had the expertise or experience to evaluate that, and were happy to sort of rely on the government's assessment. Even though at that hearing, the United Nations High Commissioner for Refugees presented very compelling, cogent evidence of serious systemic deficiencies in Rwanda's asylum system. I think 100% rejection rate of people from places like Syria and Yemen. So they were refoulement back, they were sent back, even though they must have been at risk. There was an agreement between Rwanda and Israel, similar to what had been entered into with UK, in which Rwanda had given assurances they wouldn't refoul asylum seekers, they wouldn't send them to places where they were unsafe, and yet, very soon after the asylum seekers arrived in Rwanda, they were clandestinely removed. Yeah, lots of evidence and concerns about independence of the judiciary and political pressure on the judiciary and so on. So there were lots of concerns, but the High Court sort of just didn't engage with that evidence and basically said indicated they felt this was a political decision and even though the judiciary are meant to sort of act as a check on the powers of the executive, they were reluctant to do so in this situation. So there was further resistance. The claimants appealed. Before we look at what happens next, I just think it might be helpful at this point just to look at some of the context in which this case has been heard and the environment for lawyers. So the hostile environment, obviously, Theresa May meant it in terms of the hostile environment for migrants, but that has seems to extend it to anyone who tries to sort of protect them or represent them, or could anyway impede the government's policy. So, I mean, we all know, going back to 2016, that that there's been pressure on judges, the enemies of the people headline in the Daily Mail. Okay, related to the Brexit, but it was, it was indicating that any judge that sort of stepped out of line, there was going to be much more overt criticism. Some legal academics have contributed to this pressure. Richard Eakins, who's a constitutional law professor at Oxford, is basically argued that judges are becoming too political, and that particularly in the area of human rights, he sort of says these are, the understanding of human rights is contested. There's no consensus. Even fundamental human rights like freedom from torture, he would say, there isn't a sort of consensus on what that means. And judges should not have the power in judicial review cases to decide whether policy is lawful or not. It is quite an extreme view, to be fair. I don't think most practitioners and academics would agree with him. Some would sort of go halfway maybe. Then just in September 23, there's a picture there of Jackie Mackenzie, who was a lawyer who represented one of the Rwanda claimants. She was the subject of a Conservative Party dossier sent to right-wing newspapers, which contained untrue allegations and which led to her getting sort of death threats and so on. So again, a hostile environment for those trying to represent migrants. In August 23, Home Office announced it was establishing a task force to crack down on crooked lawyers who coach illegal migrants to lie. And there's a piece there, a quote there for a piece in the Evening Standard: petrified immigration lawyers carry safety alarms and say dangerous Home Office rhetoric will stoke attacks. So this is not an easy environment for those, as I say, representing and offering legal support and advice to migrants in the situation. And just as well, the All-Party Parliamentary Group on Democracy and the Constitution report in 22 found that ministers have acted improperly towards judges, in terms of critiquing particular judgments. This may create a context in which it would be understandable for the judiciary to feel pressurised by the executive. So I think it's hard. It's quite hard, I think, at the moment to be working in this environment, and I don't know whether the High Court judges did feel intimidated or whether they genuinely had shared the sort of ideological approach of someone like Richard Eakins. But I think it's worth being aware that this is the environment in which they're working in. So back to the case, the Court of Appeal heard the appeal in June 23. By a majority of 2-1, they ruled that Rwanda is not safe. So they upheld the claimant's appeal, ruled against the government. So they did, they kind of glossed over the issue of whether Rwanda itself was safe, and focused, sort of said, well, if there's a danger of reform, well, that in itself will make it unsafe, and so we're going to focus on that. So they did feel that there was significant risk of reform, or they were much more prepared to engage with the evidence presented by the UN Human Rights Commissioner, and said they were concerned that there was a real risk of torture and inhumane treatment in breach of international law, including Article 3 of the European Convention. There was inevitably counter-resistance. The government appealed. So that led to the Supreme Court ruling in November 23. Supreme Court agreed with the Court of Appeal, and this was not in no way not certain. I think one of the solicitors for the Rwanda applicants was interviewed afterwards, and he was asked if he was confident that they would win the case, and he sort of said, well, we believed in the sort of the rightness of our case, but we were not confident. The Supreme Court, under the presidency of Lord Reid, does seem to have become more conservative, and that's been commented on by quite a few academics and practitioners, particularly in relation to sort of human rights judicial review cases. And the government was sort of issuing statements saying they were confident it was going to find in their favour. So I think there was quite a lot of nervousness about the outcome of this case. But they didn't uphold the government's appeal, and actually were really quite critical of the High Court and the reason it had given. There has been counter-resistance. So the government has now formalised the agreement with Rwanda in a treaty, which, as I say, makes it sort of legally binding under international law. And Rwanda has said that it will not refool anyone. So obviously that's the end of that. That's not going to be a worry. And the various other sort of additional safeguards have supposedly been put in place, which they say address the concerns of the Supreme Court. I guess the elephant in the room is, if they're that confident, why have they taken the second step there, which is to introduce the Safety of Rwanda Asylum and Immigration Bill, which basically says that the court can't have any further jurisdiction on the point of the safety of Rwanda, if they really believe their own promises about that. Why have they had to take this incredible step, basically, of introducing an act which says that a question of fact decided by the Supreme Court is not so. I guess they argue that in the interim things have changed, but it's hard to see how some of those concerns could have been addressed in that time. And there's been more rhetoric as well. Liz Truss has said, we've told the British people time and again that we intend to crack down on illegal migration, yet keep being thwarted by a range of spurious legal loopholes, the Human Rights Act, being exploited by activist lawyers. So that, what next? I guess it depends on whether the bill is passed, and you've probably seen in the news, it's been in the news a lot. Yesterday they had the third reading. House of Commons has basically passed it, despite some of the more right-wing MPs threatening to block it because they didn't feel it went far enough. Because basically the bill disapplies quite a lot of the Human Rights Act, but there is still a very limited right of appeal, and it does, if the European Court tried to pass an interim measure to prevent deportation, there's sort of discretion there as to whether or not to comply with that. So that didn't go far enough for some of the MPs. But anyway, they voted it through. So it's now going to go to the House of Lords. It's hard to know what will happen there. Certainly some of the Lords seem to be concerned, and we'll review it carefully. They don't there's a sort of convention that if it's in the manifesto that the Lords won't veto it, but it wasn't actually in the manifesto, so it may get vetoed for a year by the Lords. They can't stop it indefinitely, but they can sort of kick it into the long grass, and that might be enough, I suppose, if we have an election in the meantime. But if the bill is passed, there are still options. I think it definitely a case could be brought in the European Court of Human Rights. And I guess that brings us on to, is it worth doing? I mean, sorry, is it worth pursuing the Rwanda policy? Because the reality is, Rwanda's capacity is very limited. I mean, I think 1,000 asylum seekers would be a generous estimate of what they could cope with. When you think back to those figures of the small boat crossings, we're talking, upwards of 30,000 coming over. So if those asylum seekers don't go to Rwanda, and the law is saying that they are illegal migrants and they're not going to be processed here, that kind of leaves them in limbo. So it's a bit, they sort of shot themselves in the foot a bit there. It's cost millions, 240 million, according to the agreement. And I think Rwanda's now saying they might pay some of that back. I think they're getting a bit fed up with the whole thing themselves. But more is due to be paid under the agreement. Not to mention the cost of things like chartering the private planes. The one that didn't take off, that was sort of stopped at the last minute by the European Court of Human Rights, had cost apparently $500,000 to chart. And then there's all the costs as well of negotiating it, all the costs of the negotiations. So it seems to be, I think Dan Trilling said earlier in this series that it's an immoral policy, but it's also a stupid one. It doesn't actually address the issue. It's just going to cost the taxpayer a lot of money. But anyway, it seems to me that the case shows that the law can be both a tool for resistance and counter-resistance. And I guess what happens next will depend on who is in power and what they see as the priority. So I think that's it. Thank you for listening. I'm happy to try and answer any questions.
Oh, thanks so much, Kate. That was incredibly interesting and so helpful.